Hello, and welcome to a recap of our April 17, 2026 newsletter about trademarks, franchises, and other legal stuff. We discussed Mumumelon, made with renewable energy, and also some trademark infringement. What's going on with Bronny James trademark? And why do movie copyright notices use Roman numerals? I'm Tom Vanderbloemen. I'm a lawyer in South Carolina, and we handle trademark and other intellectual property matters, plus franchise and business law. We also do a goofy newsletter with stories about the law and also trivia questions and the more than occasional picture of dogs. If you like this kind of stuff or just the dog pictures, like and subscribe and see the sign up link below. Mumumelon, infringement, or creative protest? You've heard about Lululemon, but what about Mumumelon? They have a website, they even have a storefront in London. We're actually headed to the International Trademark Association meetings in London soon, so we may need to take a field trip to check it out. So is it just a knockoff or is it something else? There's an advocacy group called Action Speaks Louder, and it claims to have created what it calls this dupe activewear brand, what it also calls a deliberate and shameless copy of Lululemon. They're trying to make a point, so what is that point? The brand says it made copies of Lululemon's designs, but, as they say, made them less terrible for the environment, trying to raise awareness of Lululemon's carbon footprint and use of fossil fuels. We've included a link to the group's YouTube video in our newsletter, which you can get to below. The spoof brand says it was able to make these dupes with workers earning a living wage and in a wind and solar-powered factory, and with a plan to fully electrify its supply chain by 2040. As they say, they're not trying to compete with Lululemon, they're just trying to embarrass them, gently, in a friendly, encouraging way. The fake brand claims to be violating copyright, not the planet, and that its products are made with renewable energy and trademark infringement. So is it infringement? In the US at least, the touchstone of trademark infringement is whether using a similar brand is likely to cause confusion with the senior trademark. But is there confusion here, given that the fake brand is blatantly trying to embarrass Lululemon? Or is this just an artful and maybe legal form of creative protest and a parody? Owners of so-called famous trademarks in the United States can also sue for dilution, which involves misuse of a trademark even if there is no likelihood of confusion. Now, granted, this case is playing out in London, which apparently has a different legal system. Who knew? But with many similarities to the US system. Perhaps the bigger question is whether Lululemon would even sue, since that may simply play into the group's strategy to raise awareness. After all, the group's site seems to be inviting litigation, saying, "Bring on the Lulu lawyers," even if it also says, "Our lawyers would like you to know that this is a parody, not affiliated with or endorsed by Lululemon, created to raise awareness of Lululemon's climate impact and demand a fossil-free supply chain." We'll keep an eye on it. What's going on with Bronny James' trademark? You may have seen news that NBA star Bronny James, the son of LeBron, has encountered some pushback from the U.S. Patent and Trademark Office on a recent trademark application. So what is going on there? James, well, Nike really, filed an application for a logo for various sports apparel. The logo, shown here, incorporates a B and the number 9, apparently a nod to the initial of Bronny's first name and the jersey number he wears. The application was initially refused by the USPTO based on what the trademark examiner found to be a conflicting mark. That mark, also a logo for the B9, is owned by an individual named Raul Gomez, who is apparently affiliated with a golf-related apparel company called Back 9. You can see that logo here. The USPTO initially concluded that the Nike logo for Bronny James is likely to be confused with the Back 9 B9 logo. Now, many news stories about this are reporting about how the trademark was rejected and that it is bad news and a setback and that James' logo is not trademarked, as they say. We thought it might be worth breaking this down. So what happened? Nike filed an application to register the trademark with the USPTO, and the USPTO has initially denied the application. In the United States, at least, trademark rights are created from using a trademark to provide goods and services. Now, registration provides many benefits and additional protections, but it's not required for the trademark to exist or to be enforced. Therefore, it's not quite accurate to say that James' logo is not trademarked simply because the application to register was initially refused. It is still a trademark, just not a registered one. Some trademark lawyers even get bent out of shape when people use trademark as a verb, but whatever. Now, don't get us wrong, registering a trademark is certainly a good idea. Registration creates a legal presumption that you can use the trademark nationwide on the products listed in the registration, and this can have a lot of benefits depending on how the trademark is going to be used. Furthermore, applying to register is just one step in the process. Just like a criminal defense lawyer might say an arrest is not a conviction, an initial refusal from the USPTO does not end the discussion. Nike will have an opportunity to respond and argue that the two logos are not confusingly similar. It even has appeal rights if the examiner digs in. And there are a lot of factors that the USPTO may consider on this issue, but one is simply how similar the logos look, as well as whether other equally similar or dissimilar logos have been allowed to coexist. Now, statistically speaking, these kinds of refusals can be hard to overcome, but Nike does have resources, so it wouldn't surprise us if they do respond. After all, just because both logos contain a B and a 9, are they really confusingly similar and going to create a likelihood of confusion? That will be the issue here. Nike has other options too. It could try to negotiate what's called a consent agreement with a golf apparel company to let both companies have registrations. Or it could drop the application and use the logo without the benefit of a registration. While this could create a litigation issue later, Nike may be willing to press on and argue, if needed, that the logos as actually used in the market are not resulting in any likelihood of confusion. Or it could just change the logo. So yes, the initial refusal is probably not what Nike wanted, but it's also not the end of the line or the end of the world either. Why do copyright notices in movies use Roman numerals? You've probably seen copyright notices at the end of movies, like the one here, which actually comes from the end of the movie Airplane. Why do movies use copyright notices like this? Candidly, this is not really a frequently asked question we get, but it's also one we wondered about. And also, candidly, we don't really know the answer. We're not sure really anyone knows the answer. But from what we've read, there are some theories that it creates a bit of nostalgia and class to use Roman numerals in a copyright notice. Other people have suggested that it was a way to obscure the age of a film from audiences who wanted something new to watch and weren't quick with their Roman numerals. The Copyright Act does have a section concerning 3 things a copyright notice should contain. First, it should contain the symbol C, or the word copyright, or the abbreviation COPR. Second, it should contain the year of first publication of the work, with some exceptions. And third, it should contain the owner's name. But the statute does not say anything about how the year should actually be written. So if you like Roman numerals, you can have at it. When it comes to copyright notices, we mentioned Airplane for a reason. Its ending credits have one of the better warnings, reminding you that unauthorized distribution could result in civil liability and criminal prosecution. So there. If you like this kind of material, or just trivia questions and dog pictures, feel free to sign up for our newsletter in the link below. We hope you enjoy.